Namaskar. Today we are going to read about corporate management and governance. This is a very interesting topic and we would learn lots of things in this one. Okay, so let's delve into that what we are going to learn today. Corporate management and governance. In that, unlock the secrets of how top companies are built and managed. Ready to discover what makes a company truly powerful? Let's dive in. Second one is the certificate of incorporation. The moment a business is born, see how your dreams company get its legal wings. From paperwork to powerhouse, this is where the journey begins. Third one is the memorandum and articles of association. Every company needs a playbook. Here's how the rules are set. What your company DNA, it all starts here. Other one is doctrine of ultra vires and indoor management. Can a company do anything it wants? Not so fast. Discover the invisible boundaries that keep companies in check. Outsiders, be aware. Here's how the law protects you. All we are going to delve in this topic, that is doctrine of ultra vires and indoor management. Other one is directors, audit committee, company secretary. Meet the real power players behind every successful company. Who's really calling the shots? Let's find out the watchdogs of corporate honesty, why their role matters more than ever. The other topics are meetings and resolutions, where decisions are made and futures are shaped. From boardrooms to big moves, see how companies make things happen. Ordinary or special, every vote counts. Other topic is like basically this is a case law, as well as a topic that is rule in force versus Harbotel. In that one, operation and mismanagement, we will going to delve in. When things go wrong, who gets to fight back? Minority voices matter. Here how the law protects them. Justice for shareholders, the inside story, all these things we are going to check in this topic. Other topic is company investigation. What happens when the alarm bells rings? Uncovering the truth, how investigations keep companies honest. Other one is the winding up of companies. Every story has an ending. See how companies close their chapters. From boom to bust, what really happens when a company winds up. Other topic is corporate governance. Trust, transparency, and triumph. Why governance is a game changer. Want to invest like a pro? Start by understanding corporate governance. Good governance equal to great business. Here's why it matters. And the two other topics are different systems of corporate governance. East versus West, how do different countries run their companies, which model works best and why? Let's compare. Impact and legal traditions, how does the law shape the way companies behave? The global rulebook, why legal traditions matter in business. So let's begin. Certificate of incorporation. Under section 9 of the Companies Act 2013, its definition, a certificate of incorporation is a legal document issued by the registrar of companies, that is ROC, to confirm the formation of a company under the Companies Act 2013. The legal effect, it signifies the legal existence of the company, making it a separate legal entity. Other one is memorandum and article of association. Under section 4 MOA and under section 5 AOA of the Companies Act 2013. Memorandum of association, it defines the company's scope of activities and its relationship with the outside world. It must include the company's name, registered office, object, liability, and capital structure. And in the article of association, it outlines the internal management rules of the company. The AOA governs the company's internal affairs and the rights and duties of its member only. Doctrine of ultra vires. This doctrine asserts that any act performed beyond the powers stated in the memorandum of association is ultra vires, beyond the powers of the company and thereof void. Contracts or actions beyond the scope of MOA cannot bind the company. The famous case is Ashbury Railway Carriage and Iron Company versus Rich, 1875. Another one is doctrine of indoor management. Section 6 of the Companies Act 2013. This doctrine, also known as the Royal British Bank versus Turquoise Rule. This is the famous case which is related to doctrine of indoor management. It protects third parties dealing with the company, assuming that internal procedures such as board approvals have been duly followed. It protects protects the company, like outsiders are not expected to inquire about the internal management of the company. Director appointment, removal, positions, power and duties. Under Section 166 of the Companies Act 2013, directors are appointed by the shareholders through ordinary resolutions. Under Section 152, directors can be removed by shareholders through an ordinary resolution under Section 169, subject to the company's AOA, Article of Association. Directors are the agent of the company acting as fiduciaries for the shareholders. They have the authority to manage the company's affairs and make decisions on behalf of the company. Directors owe fiduciary duties to act in good faith with due care and in the best interest of the company under Section 166. Audit Committee. What is its role? An audit committee must consist of at least 3 directors, with 2/3 being independent. It reviews financial statements, audits internal controls, and ensures transparency in financial reporting. It is mandatory for listed public companies and prescribed classes of companies under Section 177. Not obligatory for all the companies, but mandatory for listed companies and prescribed classes of companies under Section 177. Company Secretary, qualification, appointment and duties. Under Section 203 and 205, Companies Act 2013, a company secretary must be a member of the Institute of Company Secretaries of India, ICSI, appointed by the Board of Directors subject to company's articles, ensures compliance with statutory regulations, maintains statutory records, and act as a liaison with regulatory authorities. Officer who is in default. Definition of officer in default. Section 2, subsection 60 of the Companies Act 2013 defines that an officer in default refers to an officer, that could be director, manager or secretary, who is responsible for contravening provisions of the Companies Act 2013, and the consequences for the same, it would be liable for penalties and prosecution for failure to comply with legal requirements. Liability of independent directors. Section 149 subsection 12 of the Companies Act 2013. Independent directors are not liable for acts or omissions of the company unless involved in fraud, violation of laws or misrepresentation of financial statements. It covers under Section 149 subsection 12 of the Companies Act 2013. Meetings and resolutions. Types of meetings are defined under Section 96, 97, 118 of the Companies Act 2013. Annual General Meeting, that is AGM, a mandatory yearly meeting where shareholders discuss the company's financial performance, dividend declaration, and elect directors. A meeting of the directors for making strategic decisions happens in board meeting. Extraordinary General Meeting, EGM, a meeting called to discuss urgent matters that cannot wait for the AGM. Procedure of calling a meeting, it is defined under Section 101 to 104 of the Companies Act 2013. Notice, a clear notice must be sent to all members at least 21 days before the meeting under Section 101. Quorum must be met for the meeting to be valid as specified in the company's Article of Association, and the agenda must be provided to the members detailing the business to be transacted. Company's resolutions and its kind. Section 114 to 118 of the Companies Act 2013, it has been defined. Ordinary resolution and special resolution. And other one is written resolution. Ordinary resolution passed by a simple majority, more than 50% of votes cast, used for routine decisions. And special resolution requires a 3/4 majority to pass, used for significant matters like change in MOA, AOA or capital structure. Written resolutions passed without holding a meeting but signed by all directors or members under Section 111A. Rule in Foss versus Harbottle, 1843-67 ER 189. The rule established in Foss versus Harbottle 1843 dictates that only the company itself can bridge a lawsuit for a wrong done to it. Shareholders cannot sue on behalf of the company unless the act complained of its ultra-vires or fraudulent. And there is one exception for that, that is the rule is subject to exception like when the act is illegal, ultra-vires or involves a fraud against the minority. Prevention of operations. Section 241 to 246 of the Companies Act 2013 Operation refers to the unfair treatment of minority shareholders by the majority, depriving them of their legal rights or benefits. Legal remedies. Section 241 of the Companies Act 2013 allows aggrieved shareholders to approach the National Company Law Tribunal, that is NCLT, for relief if they believe their interests are being oppressed by the majority. And grounds for application: this can include unfair alterations of the company's structure, fraud, or disregard for the company's constitution. Prevention of mismanagement, that has been defined under section 241 to 246 of the Companies Act 2013. Mismanagement involves the failure to manage the company's affairs in a lawful and prudent manner, leading to harm to its interest. Legal remedies: shareholders can seek redress before the NCLT under section 241 if there is evidence of mismanagement. And grounds for mismanagement: it includes activities such as illegal financial dealing, improper management of assets, or disregard of shareholder interests. Role and power of the Company Law Board. Section 10F of the Companies Act 1956, repealed under the 2013 Act. Establishment: the Company Law Board was quasi-judicial body under the Companies Act 1956, which has now been replaced by the NCLT and NCLAT under the Companies Act 2013. CLB had power to resolve disputes between shareholders, directors, and the company, including matters of operation, mismanagement, and winding up. It could pass orders for relief in case of operation, mismanagement, and company investigations. With the advent of the NCLT, the CLB's power have been shifted. Role and power of the central government. Section 241 to 246 and Section 11 of the Companies Act 2013 define that the central government plays an advisory, regulatory, and enforcement role under the Companies Act 2013. The government is empowered to issue directions, investigate companies, and issue order for the compulsory winding up of a company in certain cases. It can appoint inspectors for investigating the affairs of a company and intervene in case of default by the company or its director. Company investigation. Sections 210 to 229 of the Companies Act 2013 defines that a company investigation refers to the examination of a company's affairs to identify any misconduct, fraud, or illegal activities. Ground for investigation would be: investigation may be initiated by the central government or NCLT if there are reasonable grounds to suspect that a company is being operated in a manner prejudicial to public interest or the shareholders' interest. The investigation types are as follows: inspection, a routine examination of a company records to verify compliance. Investigation, a more detailed inquiry into the company's affairs typically initiated due to complaint of fraud or misconduct. And the procedure would be: the central government or NCLT can appoint inspectors or investigators to inspect company records and conduct inquiries. Inspectors have the power to access books, records, and financial documents and can summon individuals for questioning. Now the another topic is winding up companies. Section 270 to 316 of the Company Act 2013, it has been defined. Winding up is the process of closing a company, involving the realization of its assets, settlement of its liabilities, and distribution of the remaining assets to shareholders. It marks the end of the company existence as a legal entity. And the process can be either compulsory under the order of the tribunal or voluntarily initiated by the company itself. Mode of winding up of companies defined under section 270 to 318, that is voluntary winding up, and the section 271 to 300, that is compulsory winding up of the Companies Act 2013. Voluntary winding up initiated by the shareholder or creditors of the company. Compulsory winding up ordered by the NCLT, that is National Company Law Tribunal, under specific circumstances. Example: inability to pay debts of it, or if the company conducts fraudulent activities. Winding up under the supervision of the tribunal, a hybrid form where the winding up process is voluntarily initiated but continues under the supervision of the tribunal. Compulsory winding up under the order of the tribunal, defined under section 271 of the Companies Act 2013. Grounds for compulsory winding up: a company may be ordered to wind up compulsory by the tribunal in the following cases: the company is unable to pay its debts which is defined under section 271. The company has acted against public interest or has been involved in fraudulent activities. The company has not filed its financial statements or annual returns for a continuous period of 5 years. The company's affairs have been conducted in a way that is prejudicial to the interest of its members or creditors. And the procedure is as follows. A petition for winding up is filed before the NCLT, and if the tribunal is satisfied with the grounds, it may order the winding up of the companies. Voluntary winding ups, which is defined under section 304 to 323 of the Companies Act 2013. A company may opt for voluntary winding up by passing a special resolution in a general meeting. Members voluntary winding up where the company is solvent and its member declare the company will be able to pay off its debts in full within a specified period of time. Creditors voluntary winding up initiated when the company is insolvent, that is, it is unable to pay its debt. And the procedure would be a liquidator is appointed to manage the process, including selling the company's assets, paying off its debts, and distributing any remaining assets to the members. Contributories, which is defined under section 305 of the Companies Act 2013. Contributories are individuals or entities, usually shareholders, who are liable to contribute towards the company's debt in the event of its winding up. The liability of contributories depends on the type of shares they hold. For example, holders of unpaid shares may be required to pay the balance of unpaid capital. Contributories are called upon to pay debts in the order of priority as determined by the winding up process. Payment of liabilities. Section 327 of the Companies Act 2013 states that priority of payment in the winding up process, liabilities are paid in the specified order. Liquidation expenses, fees and cost of the liquidator, preferential creditors, salaries and wages due to employees, debts owed to the government authorities, etc. Unsecured creditors, other debts not falling under preferential categories, shareholders after all debts are settled and any remaining funds are distributed to the shareholders based on the class of shares they hold. Distribution of assets. Once liabilities are paid, the remaining assets, if any, are distributed to the company's members in accordance with their right and the shareholding structure. Corporate governance. Clause 49 of the Listing Agreement and the Companies Act 2013. Definition. Corporate governance refers to the system, principles, and process by which a company is directed and controlled. It ensures transparency, accountability, and fairness in the management of companies, protecting the interest of shareholders, employees, and other stakeholders. And the importance of corporate governance is investor confidence, promotes trust in the company, encouraging investment, risk management, helps in the effective management of risk and legal compliance, foster long-term growth and profitability while protecting stakeholder interest in terms of sustainable growth, and global competitiveness. Strong governance standards improve the company's competitiveness in the international market. Different system of corporate governance. Clause 49 of the Listing Agreements and section 149 to 178 of the Companies Act 2013 defines that Anglo-Saxon model, it means shareholder model, focuses on shareholder rights and financial performance. The board of directors is primarily accountable to shareholders, predominant in the UK, USA, and other common law countries. German-Japanese model, that is a stakeholder model, focuses on a broader set of stakeholders, including employees, creditors, and the community, rather than just shareholders. Board members may include employee representatives. Predominant in Germany and Japan. India model. India follows a hybrid model combining elements of both Anglo-Saxon and German models. It focuses on shareholders' interests but also incorporates regulatory frameworks for broader stakeholder welfare. Impact of the legal traditions and the rule of law on corporate governance. Clause 49 of the Listing Agreement, Companies Act 2013, and SEBI regulations. The legal tradition of a country significantly influence its corporate governance system. Countries which common law traditions such as UK and the US tend to focus on shareholder primacy, whereas countries with civil law traditions such as Germany and Japan place more emphasis on stakeholders. A strong rule of law ensures that companies are held accountable for their actions, minimizing corporate fraud and misconduct. Impact on governance, transparency and accountability. A robust legal framework ensures that companies are accountable to stakeholders. Corporate ethics, it strengthens corporate responsibility and ethical decision making. Legal reforms of corporate governance in India. Companies Act 2013, SEBI regulations and clause 49 of the listing agreement. Need for reforms. Following corporate scandals, example Satyam, India introduces legal reforms to enhance corporate governance standards and restore investor confidence. The Companies Act 2013, it strengthens governance through provisions related to the board structure, independent directors, corporate social responsibility, and enhanced disclosures. SEBI, Securities Exchange Board of India guidelines. SEBI's regulatory framework provides for stricter compliance on matters such as shareholder rights, board independence, and disclosures. Clause 49 of the listing agreement requires listed companies to comply with governance norms like board composition, audit committee, and disclosure requirements. Report of the various committees on corporate governance. The Kumar Mangalam Birla Committee Report 1999 recommends measures for improving the board structure, disclosures, and role of independent directors, leading to Clause 49 of the listing agreement. The Narayan Murthy Committee Report 2003 focused on the importance of corporate responsibility and transparency and the role of auditors. The J.J. Irani Committee Report 2005 suggested reforms for strengthening corporate governance under the Companies Act 1956. The Uday Kotak Committee Report 2017 recommended further enhancement to the governance framework, including strengthening the role of independent directors and board diversity. Statutory reference, the Companies Act 2013, SEBI regulations, clause 49 of the listing agreement. These are most important things. Emerging trend based on the recommendations of the committee in the Companies Act 1956 and the listing agreement with a special reference to the clause 49. Changes post Birla and Murthy reports. The introduction of clause 49 in the listing agreement emphasized the need for independent directors, a proper audit committee, and enhanced disclosure standards. Clause 49 states strengthened the role of independent directors and increased their accountability, mandated the formation of an audit committee and specified requirements for financial disclosures, introduced provisions for corporate governance practices to align with the international standards. Post-Irani and Kotak committee reforms enhanced the role of independent directors, proposed gender diversity in boards, and focused on improving board dynamics. Statutory reference, clause 49 of the listing agreement, Companies Act 2013. Corporate social and environmental responsibility, that is CSR. Statutory reference, section 135 of the Companies Act 2013, Environment Protection Act 1986. CSR refers to the responsibility of companies to contribute positively to society by addressing social, environmental, and economic issues. Key aspects of CSR: social responsibility. Companies are expected to contribute to social welfare through activities such as education, healthcare, and poverty alleviation. Environmental responsibility. Companies are required to minimize their environmental impact through sustainable practices such as waste management, energy conservation, and carbon footprint reduction. Economic responsibility. Ethical business practices, fair wages, and economic inclusion are key elements of CSR. Legal framework. Mandatory CSR provisions under the Companies Act 2013. Company meeting a specific criteria, turnover above rupees 1000 crores or net profit of rupees 5 crores must spend 2% of their average net profit over the last 3 years on CSR activities under Section 135 of Companies Act. Environmental laws also state that companies must comply with environmental laws such as the Environmental Protection Act and the Air Prevention and Control of Pollution Act 1981, among others. The importance is that reputation building. CSR strengthens a company brand image and creates goodwill in the market. Sustainability encourages sustainable business practices that can lead to a long-term profitability. Stakeholder engagement enhances relationship with a stakeholder, including customers, employees, and investors, by demonstrating ethical conduct. That's it for the today. And if you found this video helpful, hit that like button, subscribe for more legal insights, and drop a comment with your thoughts or questions. Thanks for watching and see you in the next video. Thank you.